Hello, everyone. This is Brad Geyer, thanks to the support of formerfeds.org and listed on X as Former Feds. They're doing great work and support your efforts to protect financial freedom. Today, I'm here to talk to you about the latest developments regarding our ongoing legal efforts. And I want to start by acknowledging the complexities of our situation. Our legal landscape has changed, and it's important for all of us to be on the same page. I also want to acknowledge the remarkable unity you've shown. Over 5,000 individuals, 6,000 I'm pretty sure, but we have 5,242 documented, who've entrusted us with a mission critical to their and your financial future, the recovery of their investments, which have been unjustly seized. These assets have been swept up in the machinery of a legal system foreign to you, a system to which you owe no duty and within which you've performed no action that justifies the U.S. Department of Justice action against your money. Since our last briefing, we've achieved two significant victories worth highlighting. Firstly, our persistent efforts have led to the Department of Justice recognizing that the funds of Himalaya Exchange, your investments, should not be entangled in the bankruptcy proceedings. This is a crucial step in safeguarding your assets, and I would like to thank the Department of Justice for this important concession. Secondly, our actions have prompted the bankruptcy trustee to file for a stay. A stay, in legal terms, is essentially a pause button. When the bankruptcy trustee files for a stay, they're requesting the court to temporarily halt certain proceedings or actions. Again, I would like to thank the trustee for taking this action. The trustee's action effectively simplifies our battle from a two-front battle to a one-front battle. This development is particularly beneficial for those concerned about the broader implications of this case, including what is seen as a lawless prosecution, by many of you at least, as a lawless prosecution of Miles Go. But now I should note that many members and supporters of former feds watching this are also concerned about Miles Guo's fate because they recognize that Mr. Guo was trying in vain to warn them about dangerous hospital interventions and medical experimentation to which they ultimately tragically lost loved ones. Sadly, Mr. Guo's protestations and warnings could not get through the information cocoon that they had all been placed in by a variety of entities that include, sadly, the United States government. The filing of the stay by the bankruptcy trustee will permit Gao's legal team to dedicate their full attention to this aspect of the case. I understand the anxieties and frustrations that come with this process. Many of you are eager to recover your investments and are rightfully concerned about the principles at stake here. I want to assure you that every step we take is aimed at not only recovering your assets, but also safeguarding your legal rights. Furthermore, today, we're addressing a significant step we've taken in our ongoing efforts to protect your investments and freedoms. In a submission made on Friday, we addressed the critical issue of irreparable harm that threatens the financial stability of all of you. Our motion for reconsideration challenges the March 7th, 2024 order by the court head-on, respectfully, seeking to prevent further damage to your investments caused by the ongoing asset seizures. Within the motion, which you can find the full copy of on Himalaya Restoration and on Former Feds, both on X, you can see that we highlight several key points. We address the fundamental misstep in this case, the assertion of jurisdiction by the United States government over our clients, none of whom are U.S. citizens, residents, or nor do they have any agency relationship inside the United States with the government or otherwise. The question of jurisdiction is not and should never be a one-way assertion by a single entity, even the United States government. And should these allegations against certain defendants in the United States territory hold true, it is not indicative of any wrongdoing by the Himalaya Exchange, most certainly not by the Himalaya Exchange's customers. These operate entirely outside of United States jurisdiction. We demand a fair opportunity for our clients to voice their side of the story in full detail, something that has not yet been afforded. If there were any truth to the notion of criminal profits, we would presume the U.S. government would show some of that proof at large. They would show large, suspicious transactions, make some kind of showing that stand apart from our clients, our 5,000 plus clients, legitimate bona fide transactions. Yet, there's been a resounding silence on the part of the government, which raises serious concerns about the integrity of the allegations with which we face. However, should the financial activities within the exchange merely reflect the legitimate investments of our clients, the foundation of the current legal actions collapse. It is this absence of such evidence and the refusal to engage in dialogue that further exacerbates the injustice imposed on our clients by a system from which they rightly expect protection. In regards to irreparable harm, furthermore, we addressed in our filings the critical issue of irreparable harm that threatens your financial stability. We implored the court to reassess the motion on your behalf, pursuant to Rule 41G, and it's our position that this transcends mere legal technicalities and touches the real financial suffering of you and our clients. For further context, the customer's motion was considered under the assumption that there would be no irreparable harm, that is money later is the same as money today other than interest. However, we've addressed this point numerous times. And notably, to date, the DOJ has failed to respond or provide any meaningful reason or justification to retain our customers' money. The court has cited the principles of law and precedent, most of which the customers agree with, but disagree that there's been any factual showing to support assuming the irreparable harm. The government's also simply ignored the critical point of contention that the continued unjustified seizure of your funds has already caused substantial devaluation of Himalaya coin, with severe financial losses as a result. The government has displayed a glaring contradiction in its stance regarding the Himalaya Exchange's digital currency, seemingly speaking out of both sides of its official mouth. In the bail hearings of Ms. Wong, it pointed out in document 44 that on the one hand, the coins may have defrauded investors because they have far lesser value or no value at all. And on the other hand, they speculate that these same coins are valuable enough for defendant Wong to possibly use them to escape. This dichotomy speaks volumes about the government's recognition of value which is now at risk due to its mistaken jurisdictional overreach. The government has elected to seize the reserve of the Himalaya Exchange. They've concluded their investigations and no doubt by this time should be in a position to identify which funds they believe are attributable to the defendants. It would be proper and justified, perhaps, to ring-fence these portions of your money and set them aside to remain until the forfeiture matter can be resolved and the criminal matter can be resolved. However, the DOJ has instead seized all the HTO reserves and held on to your money, and this can have no bearing on the trial. I find it hard to believe that the U.S. government is going to use as a court exhibit hundreds of millions of dollars in currency as a court exhibit to roll out into the courtroom. I can't see that happening. I doubt they see that happening either. The court is asked not to ignore these genuine, compelling reasons and to list the case urgently for a motion to be heard now. The situation is pressing. Our innocent clients who are just bystanders to this litigation now face substantial financial harm. Our demand for restoration of the reserves is critical, not only to enable customer redemptions, but also to protect the full value of their HCN asset. For those of you tuning in who may not be familiar with the workings of the Himalaya Exchange, and to understand how this fits in more broadly to the fight for economic and financial freedom, let me clarify the exchange's structure and its current situation. The exchange operates two digital currencies. First is HDO, Himalaya dollars, akin to a stablecoin, backed dollar for dollar by cash reserves and seized by the Department of Justice. Then there's HCN, or Himalaya coin, a tradable cryptocurrency whose value fluctuates based on market demand, much like stocks in a company. These coins can be used for investment as digital currency or for conducting transactions like using PayPal or Venmo. When customers sign up with the exchange and pass the stringent Know Your Customer checks, which is an additional level of checks on top of what the financial institutions put you through, these HDOs can be used to purchase HCNs for trading. Customers may have a mix of HDO and HCN in their accounts, depending on their activities and their appetite for risk, much like having a portfolio of cash and stocks. Sales of HCN convert back into HDO and vice versa. We argue that this situation merits special consideration under USC Section 853N and requires urgent judicial attention. The term we use, irreparable harm, is more than legal jargon. It represents the severe and lasting prejudicial impact these actions have on each one of my clients. Our position is clear-cut. The relentless seizure of assets is indefensible, and we are advocating for a prompt and equitable resolution. It's the only fair thing to do. We are resolute in our mission to reclaim the reserve funds vital to the exchange's ability to liquidate your digital assets. In essence, the restoration of the Himalaya Exchange funds is more than a financial imperative. It embodies a stand for justice and liberty. In Friday's motion, we also address recent statements in the government filing docket 233, where the government indicates the following, and I'm paraphrasing. The government wishes to note that it does not believe the assets that the government has seized should be transferred to the bankruptcy estate. Personal note here, and a professional note, thank you to the Department of Justice who are making that important concession. This is a step in the right direction to remediate this horrendous wrong that's been done on my clients. But it could be interpreted that the Department of Justice may be planning to keep the assets it believes are connected to the alleged criminal activities within the Kwok enterprise. And it could be interpreted to mean that they're giving this or intend to give this money back to some other victims, assuming they exist, who were allegedly harmed by those crimes. The government's noted that if there are disputes, whether with the trustee or anyone else who has a claim, these will be sorted out after the criminal case is over. The government's so-called assurance is, frankly, seems at least, frankly, nothing more than an empty promise wrapped in bureaucratic language. It's a conditional statement that offers a possibility of returning funds to unnamed victims, not explicitly to my clients or members of the exchange. Contingent on, we really don't know how many levels of approval we need from the Department of Justice itself. My clients' funds were put into a custodial bank account to be held in trust by the Himalaya Exchange. Our understanding is that these funds remain there, backing up the investments in the Himalaya Exchange. Nobody else should have access to or should be able to draw down from my client's funds. This is what's fair. This is what justice requires. In my view, it's less than honorable that the government presumes that the authority to arbitrarily decide the outcome of restitution without transparent criteria, effectively playing judge, jury, and potential executioner of our clients' financial futures, is unacceptable. It's time for the Department of Justice to step up, to take responsibility, and to ensure that every single one of you is reimbursed to the last cent. We demand transparency, we demand fairness, and above all, we demand immediate action to rectify this grave injustice. Furthermore, in response to the recent discussion in court, I wish to assert that retaining the funds of innocent parties for the duration of a trial serves no practical purpose. It is understood that the court recognizes the need to secure evidence for trial, but as I said before, no one's going to be hauling in hundreds of millions of dollars in currency and using that as a court exhibit. Therefore, thereby, we assert that there is no justifiable reason for these funds to be held and not returned to the rightful owners immediately. Finally, ladies and gentlemen, the law calls for return of your funds for other reasons. The current hold on property from parties who aren't charged by a crime defies the due process that would ordinarily be assigned to you if you are U.S. citizens. You've been pulled from outside the United States into a venue where you have very few rights, certainly not protected by the U.S. Constitution. This is unconscionable. It seems unfair, and frankly, it seems un-American. None of you are implicated in the indictment. You've clearly been denied due process in getting your funds back. The principle is clear. One cannot be stripped of property without the chance to challenge such action, and you've not been afforded that, and you should be. We can consider the rulings as we laid out in our motion for reconsideration in cases like United States v. $140,000 in U.S. currency and in D. Almeida v. United States, which set the standards for how seizures must respect fundamental rights and the importance of preventing irreparable harm to individuals' livelihoods and reputations. These precedents are particularly relevant as they address the consequences of seizing property before trial. They caution against the reckless disregard for individual rights, reminding us that seizing assets without due consideration of the owner's interests or the harm they may endure is against the very ethos of our legal system. My clients are already facing the severe repercussions of these actions, from financial losses to the depreciation of their assets because they cannot access their own funds. The government's refusal to release the HDO reserve, despite having completed their investigation, is not only unnecessary, but inflicts continued distress on the innocent. They can't pay to invest in businesses. They can't pay to invest in tuitions, in medical procedures, moving expenses, all the array of things that human beings want to do in a system that's deeply steeped in financial freedom, they're prevented from doing, and that's unconscionable. The application of these principles should be even more rigorous when it comes to innocent bystanders, such as you, who've not just been overlooked, but you've been outright ignored. In these particular cases, the law establishes that the government is not permitted to freeze assets without providing victims the opportunity to argue their case. In this case, your voices haven't been able to be heard. This breach of due process goes against the very grain of our justice system and the protections it's supposed to guarantee. This is America, and we are a system based on fairness. We urge the court to rectify this injustice and to ensure that you are given the fair hearing that you are owed. As the value of HCN declines due to the seizures, our clients, like those affected in United States v. James Daniel Good Real Property and Kaylee v. United States, should have the right to challenge these actions to prevent further loss. The failure of the government to provide a strong justification for retaining all seized accounts en masse calls for immediate rectification. The legal underpinning is clear. The government must have a substantial reason to retain property before trial. The prolonged hold on your funds without a meaningful judicial hearing or a compelling need is an overreach that the Department of Justice must correct if it really is interested in maintaining the reputation of being fair and just. In closing, the law demands that when innocent people have their money taken unlawfully, that it should be returned. You've been wrongfully deprived of your funds for doing nothing more than being innocent bystanders who were attempting to engage in financial freedom and use an exchange lawfully to live your life. And we've requested that the court redress this injustice by reassessing the matter urgently, ensuring justice is done, and frankly, to make sure that you get your money back. And I believe you are going to get your money back. Thousands have placed their faith in the U.S. justice system. On a grander scale, billions have put their faith in the U.S. justice system, which is firmly based on rule of law as an example for the rest of the globe. And we expect the U.S. government to live up to those lofty expectations of the rest of the world. I want to reaffirm our commitment to you. Our team is tirelessly working to navigate these legal complexities, seeking not only the return of your investments, but also to uphold the sense of justice and accountability in this process. Your trust and patience are invaluable to me as we pursue every possible avenue to safeguard your interests and secure a favorable resolution. We are committed to transparency and will keep you informed every step of the way as we appeal to the U.S. Department of Justice to please release your funds, and we appeal to the court to please step in and address this horrible misjustice. Thank you so much for your time. Thank you so much for your trust, and have a great day.